Hello, my name is Yane Svetiev. I am a Fernand Braudel Fellow at the Law Department here at the EUI, and I also teach at the University of Sydney Law School in Australia. I would like to thank, first of all, everyone for this invitation to speak to the interdisciplinary research cluster on the crisis of expert knowledge and authority. And I will speak on the subject of my current research on peer review in market regulation. Now, peer review is a tool that's increasingly used in transnational governance. I became interested in this mechanism as part of my work on experimentalist market regulation in the European Union and transnationally. Now, in a research project at the European University Institute, which was on European regulatory private law, I observed that there was a formalization of peer review mechanisms in market regulation in the European Union in areas like competition law, finance, telecoms, and energy. And as we'll see in a moment, peer review is also very common, even if not very well studied, as a mechanism in transnational governance. So currently we have a research project with my colleague from the Sydney Law School, Andrew Edgar, funded by the Australian Research Council, where our object is to empirically study some of these peer review frameworks in global finance. Now, by way of background, peer review was apparently pioneered as a governance format at the OECD, the Organization for Economic Cooperation and Development, which is a kind of international organization that focuses on research, study, and dissemination of good practices. Also, we as academics are familiar with peer review as a mechanism for governance used by communities of specialist expert knowledge. But what we might ask is, what does peer review mean in the context of regulation? Broadly speaking, across all of these formats, what it involves is policy and decision-making in one jurisdiction being subjected to review by panels or officials or experts drawn from other countries. And now these peers can be national regulatory officials, they can be international organization officials, they can be practitioners or even academic experts. Peer review, therefore, I would say, brings into focus the question of the interaction between expert and political or democratic decision-making, if you want, and between the national and the international level. And these days, we observe it on a daily basis as we live through a pandemic. So cross-national comparisons of measures adopted and their effects are quite common, both informally in the media, if you want, but also in more formalized settings of transnational cooperation. Now, to illustrate the ubiquity of peer review, I would like to show you a slide. I'll just share my screen. So on this slide, you can see 27 examples of transnational peer review in international organizations or networks in which many of you might be able to recognize your own fields and areas of research. And in my experience, once you start looking for peer review mechanisms in various regulatory or policy-making settings, you tend to find it almost everywhere. So on one side, on the left side, you can see examples from the European Union, where, as I mentioned a moment ago, peer review is often a formal prerequisite of regulatory action in many areas. And some of these frameworks are mentioned in the book chapter that I distributed. Whereas on the right-hand side, you can see some examples from the global arena, and you can see that it ranges from finance to food safety to rule of law, disaster management, to things like terrorism and football violence. Now, looking at this broad range of areas where peer review takes place, you may well ask, well, what is the basis of these reviews? how are they conducted, and what exactly do they review? Who are these peer reviews addressed to? Do they and should they have any effect on national decision making? And how do these transnational frameworks for peer review interact with the domestic oversight of regulators and policymakers by politicians, legislators, and even judges? I'll stop sharing for the moment. These are important questions I would suggest for at least two reasons. First, delegations to independent expert agencies have been on the rise around the world for some decades, particularly going hand in hand with processes of deregulation and privatization of certain formerly public services. And secondly, these independent regulators are supposed to act on the basis of expertise and even to be isolated from politics and political influence. But at the same time, they are also increasingly networked at a global level. And those networks of regulators provide both standards and practices that their members should follow, as well as peer review as to whether those practices are in fact being followed. Now, before we look at some examples in more detail, I want to highlight a few points that may be of specific interest to this cluster on the crisis of expert knowledge and authority. So first, independent agencies are often justified as repositories of technical expertise that also resolve time and consistency problems of political decision-making, so that they ensure policy stability on the basis of expertise. Taking that on board, you might say, well, it's unsurprising that these sort of regulatory settings would borrow a mechanism that has been used to safeguard disciplinary expertise, as peer review does, for example, in the academic setting. But paradoxically, what we'll see is that precisely in settings where there is very, very high levels of uncertainty, sometimes called Knightian uncertainty, in those sorts of settings, both regulatory and expert decision-making become limited and constrained. And this is a point to which I will come back later. Now, in understanding the set of questions that I asked earlier about the purpose and effect of peer review, one key question that we have to ask or look at is the format of peer review, which, as we'll see in a moment, is not common in all of these different peer review frameworks. So lawyers such as myself, we know what judicial review of regulatory agency looks like. And both lawyers and political scientists might know something about legislative or ministerial oversight of regulatory agencies. We as academics also know a common format for peer review, where two or more disciplinary experts basically review our work and decide if it makes a sufficient contribution, if it's innovative enough so that it can be published or funded, and whether it takes proper account of existing knowledge. In the regulatory world, we'll see that we observe very different formats of peer review, okay? So they don't follow a common design. I'll share my screen again so that I can show you some examples. So the first example from the transnational level is from the Financial Stability Board, which was created via the G20, largely informal grouping of nations following the financial crisis that exposed weaknesses in financial supervision. Now, peer review of the implementation and effectiveness of the standards developed by standard-setting organizations is actually one of the key functions of the Financial Stability Board. So you will notice it says peer reviews focus on the implementation and effectiveness of international financial standards developed by standard setting bodies and of policies agreed within the FSB, the Financial Stability Board. Reviews focus on the implementation and effectiveness of regulatory, supervisory or other financial sector policies. So it reviews the implementation of standards developed by standard setting organizations. These typically are either agency networks or private standard setting bodies, such as those on, for example, accounting standards, that do not have formal powers to make binding rules. But they also, as you can see, focus at the policy level on a much broader set of regulatory, supervisory, and other financial sector policies. The Financial Action Task Force is again focused on the financial sector. It develops standards on money laundering and terrorist financing. And again, as you can see, it implements peer reviews of each member on an ongoing basis to assess levels of implementation of the task force recommendation, providing an in-depth description and analysis of each country's system for preventing criminal abuse of the financial system. Okay, so these are two transnational examples from the sphere of finance. Now we can have a look at some examples from the European Union, where we can see this formalization in binding legislative instruments of the requirement of peer review, either of past regulatory action or even before regulatory action is taken. So in finance, Article 8 of the ESMA regulation establishing the European Securities and Markets Authority, you see that there is one of the tasks is to organize and conduct peer review analyses of competent authorities, including issuing guidelines and recommendations and identifying best practices to strengthen consistency supervisory outcomes. Now I focus here on ESMA because this is what we're studying with my colleague Alexis Galan, currently at the University of Bonn, but of course equivalent provisions exist for other financial supervisory authorities in Europe. In competition law, you see that the Commission, before it takes a decision on whether there was a violation or not, or even before it takes a commitment decision, must consult an advisory committee, which is composed of the representatives of the competition authorities of the member states. And we can also see that sometimes a decision of a national competition authority can also be placed on the agenda of the advisory committee. Again, in telecommunications or electronic communications, where a national authority intends to take a measure, so this is some kind of a regulatory measure, including a remedy, it must make the draft measure accessible to the Commission, to BEREC, which is the body of electronic regulators at the national level, electronic communications regulators at the national level. And it must also provide the reasoning on which the remedy is based, okay? And then we're told that the National Regulatory Authority, before it adopts its final measure, its final decision, it must take utmost account of the comments of other national regulatory authorities, BEREC and the Commission. Now, as you can see, you can kind of go through the various EU frameworks and you will find, similar, though not identical provisions with respect to the regulation of energy, food safety, chemicals, and so on and so forth. Now, in the research that we are conducting, we're interested both in the question of how peer review is conducted, who is consulted as part of these review exercises, but also what are the effects of peer review reports or recommendations, either as a formal or as a practical matter on how agencies exercise their regulatory discretion. Now, looking at the formal effect of agencies, if you want their legal effect, in transnational settings, peer review reports are typically regarded as non-binding in the sense that they provide recommendations. Now, you might say, but who are these recommendations to? Who are they addressed to? Who is supposed to implement them? One possibility is that they are recommendations to national legislatures to change certain aspects of national law. As such, they are formally non-binding. However, peer review recommendations can also sometimes have an effect which bypasses national legislatures or executives. In particular, agencies can change regulatory practices as a matter of their own discretion to follow what their peers in other countries are doing. So in finance, for example, this was often the case with the adoption of macroprudential policies by national prudential regulatory agencies, which was done just as a matter of exercise of their discretion as to how they supervise the national banks. Now, again, on the formal effect, in the European Union, we can observe some novel and more interesting formulations, which do give peer review recommendations some kind of a legal effect. The legal effect is that the national authority or the decision-making authority must take utmost account of the peer review body's recommendations, or that the authority in taking a decision must either comply with the peer review recommendations or explain why it diverges from the peer review recommendations. Now, in the EU context, these two alternative formulations, utmost account or comply or explain, seem to have been given, the same interpretation, where you either have to follow what has been recommended or you have to provide an explanation as to why you're not following it. And sometimes in the European Union, as in the last bullet point on this slide, the obligation goes even further, whereby the national authority, in this case for telecommunications, together with its peers, the Commission, BEREC, they must work together to adjust and develop the proposed regulatory measure that the national authority was intending to take. Okay, so you see Commission, BEREC, and the relevant national regulator shall cooperate closely to identify the most appropriate and effective measure in light of the objectives laid down in the legislation, while also taking due account of the views of market participants and the need to ensure the development of consistent regulatory practice. So you can see a sort of a range of obligations, from being purely, non-binding recommendation to possibly being non-binding but influencing discretions, to having, comply or explain obligations, to actually having the peer review body and the regulator concerned working together to develop the measure that is to be implemented at the national level. Now I'll stop sharing again. The next question that I want to turn to, which I foreshadowed earlier, is the question of the purpose or the function and the effect of peer review. And in considering this question, one starting point is the literature on transnational regulatory networks, which claims that in the absence of formal enforcement mechanisms, regulatory networks must use informal mechanisms like reputation and socialization in order to ensure convergence to the common norms and practices that are developed within those networks. And so we might say that peer review can be used as a mechanism of collegiality, some authors say, or peer pressure, so that everybody converges to the norms and practices developed within the network. The peer review format makes the practices of national regulators observable to their international peers. So we can see what different authorities are doing. We can see whether they're following our common practices or whether they're diverging from them. And so by making the actions of national authorities observable, it can enhance this sort of soft convergence to the common norms based on both incentives and on social norms. Now, from a legitimacy point of view, which is really of interest to legal scholars, this informal convergence through peer review can be seen as very problematic. This is because transnational peer review can be seen as another way to expand regulatory discretion and to help regulators escape domestic oversight and constraints. You have all of these regulators getting together in an opaque global forum. They decide what norms to follow, and then they supervise each other as to whether they're following those norms without any reference to, what their domestic overseers would like them to do. So if you're worried about unaccountable international expertocracy, this sort of scenario sounds like a nightmare. Now, some critics also say that vested interests, so big business, will find its way of taking part and influencing these opaque deliberations at the transnational level, and they will influence the outcomes of those deliberations in a way that more dispersed interests like consumers, for example, will not be able to. And so from the informal cooperation point of view, peer review might help and peer pressure might help regulatory convergence, but it also looks quite illegitimate. Moreover, another problem is that this kind of peer pressure to converge to the norms that we agreed upon can also discourage regulatory innovation by basically essentially imposing the conventional wisdom on all regulators around the world. So one question that we might ask is whether peer review is always and necessarily about peer pressure to converge to conventional wisdom, or can it have some other functions? Now, I'll start sharing my screen one final time. And one key question is, therefore, as I had foreshadowed in the title for this talk, is peer review basically a mechanism for imposing the conventional wisdom, or can it also be a mechanism for regulatory innovation? And perhaps we can also ask a similar question when we think about peer review in the academic context. Now, the chapter I distributed for the cluster is from my recent book on experimentalist competition law and the regulation of markets. In that chapter, I draw on the European Union and global governance literature to identify different possible functionalities of peer review, which first do not necessarily have regulatory convergence as a principal objective, and second, that do not raise the same kinds of legitimacy concerns that I talked about just a moment ago. And so based on the literature, you can say, well, transnational peer review could be something that's limited to technocratic questions, as in trustee governance, which focuses on the optimal or best enforcement practices, and specifically aims to exclude issues that involve political and value choices, such as issues that involve policy trade-offs or have distributional consequences. And as we'll see in a moment, many peer review frameworks seem to be justified in this way. Secondly, transnational peer review can also be a way to access a transnational pool of scientists who can sublimate the current scientific consensus to aid regulatory decision-making in areas which rely heavily on science, as happens through the EU agencies like the European Food Safety Agency and the European Chemicals Agency. Thirdly, peer review can also be a mechanism of transnational administrative law. It can focus on the decision-making practices and procedures of regulators to test whether they comply with public law values and good administration practices like transparency, participation, legality, as a kind of due process check on what agencies do rather than on the substance. And finally, of particular interest to me, peer review can also be used as a mechanism of experimentalist governance, which tries basically to cope with the uncertainty that besets regulatory decision-making by giving national regulators freedom to tailor their own solutions, their local solutions, but at the same time, subjecting those local solutions to monitoring, both of their design and their effects, as a way to also revise the common rules of the regulatory regime. Now I'll stop sharing at this point. As I mentioned, whereas in the work that I just referred to, I was looking at the European Union. Our current focus is on the use of peer review in global financial regulation. And as this project relates to the work of this cluster, it is particularly interested in the question of whether the authoritativeness of peer review exercises at the transnational level is based on the expertise of those who conduct these reviews. Informal regulatory networks in finance have always been very, very important in developing transnational standards. The original literature on regulatory networks actually drew quite heavily on the networks, for example, for central banks to develop prudential banking standards within the Basel Committee. So they have always been important as sources of standards formally non-binding, but typically followed at national level. But at the same time, the global financial crisis revealed very significant weaknesses in the financial stability frameworks that were developed through those pre-existing networks. Many have also argued that it revealed the limits of expertise, and particularly of economic expertise in financial regulation. So one way this argument is put is that economists did not have much to say about the financial crisis. Now, interestingly, in the aftermath of the financial crisis, you might expect that at the transnational level, the response would have been more binding standards, more control. And yet instead, what we see is an intensification of regulatory peer review, again, within informal, non-binding networks. Not only that, but even the work of formal international organizations, such as the International Monetary Fund, is being co-opted into the peer review exercises that are conducted as part of the Financial Stability Board. And so IMF programs for surveillance and reporting, like the Financial Sector Assessment Program, and the reports on the observance of standards and codes are being both transformed and used further in peer review by the Financial Stability Board. Now, by way of background and by way of some preliminary findings about understanding the effects of transnational peer review in finance, we can look at some cases where there has been a conflict between transnational peer recommendations and domestic regulatory practice, particularly in the country where I am based in Australia. And so there have been instances where local choices in Australia have been inconsistent with transnational peer review recommendations. And one question that we might ask is, well, how do we characterize this conflict? Does it reflect, number one, parochialism, where national practice basically ignores international best practice? Is it a case where transnational peer review ignores good and maybe even equivalent regulatory standards in certain jurisdictions like Australia, and so thereby reinforces conventional wisdom by discouraging innovation and local tailoring? Or can we say, three, that there is some sort of a scope for productive dialogue and mutual learning about regulatory practices between the transnational and the national level through exploring the reasons for this conflict? Now, in these cases that I will briefly mention, Australia domestically has not adopted the recommendations that have been suggested by the transnational peer reviewers, but these recommendations have actually triggered some domestic deliberation. One interest that you might have is whether the peer review recommendations from transnational peers are seen as authoritative and why. When there is domestic deliberation about these recommendations, who participates in those deliberations and who doesn't? Now, one conflict in the Australian context related to the independence of the Prudential Regulatory Authority, APRA, transnational peer reviews repeatedly stated that the ministerial power to provide directions to the Prudential Authority in Australia was inconsistent with the international standard for agency independence. Now, if you think about this, you have a power at the national level for the minister to direct an independent agency. International peer reviewers say, no, you shouldn't be doing that. That's inconsistent with independence requirements. If you're worried about, international expertocracy running wild, then you might say, well, this is just another effort to disembed the national regulator from domestic controls. But as we'll see in a moment, the story is a bit more complicated. The ministerial directions powers seem to be included as a matter of course in legislation in Australia to oversee independent regulators, but it is rarely or in fact never used. So it doesn't seem like it's a very effective mechanism of oversight in the Australian setting. So that's something that, the domestic level can learn from this interaction. At the same time, however, at the transnational level, both the scope and the rationale for prudential authority independence has not been well motivated. So that's something that the transnational level can also learn from this conflict. The other two cases of conflict relate to recommendations about reducing moral hazard in the financial sector, based on the expectation that there would be a public bailout of banks in cases of systemic instability. So one recommendation from the peer review is for extra capital holdings by domestic systemically significant banks. And another recommendation is about having an ex ante funded deposit insurance scheme in the case of bank failure, whereas in Australia, the deposit insurance scheme is funded ex post. Now, the substance of these is not so much of interest to us in this talk. What's important is that both of these recommendations are presented as expert-based consensus on best practice. But actually, implementing them does involve policy trade-offs and distributional consequences. Both recommendations would increase the costs of Australia's banks, and this would have consequences, for example, for the interest paid by borrowers. Notwithstanding the fact that you can see that these questions presented as expert consensus are actually political questions, but domestically, these questions were not really questions of political conflict in Australia. Both political parties, when in government, followed similar policies. The issues were of limited parliamentary debate, and often the governments sought to basically delegate these questions to the Prudential Supervisory Agency or to other fora to deal with. And where there is domestic deliberation, it's dominated, of course, by concentrated interests in the banking industry, with almost no participation from dispersed interests like customers, depositors, and taxpayers. Now, the work on the project that I was just describing at the very end is at its very start, and so we can only make some tentative conclusions. So those tentative conclusions might suggest, number one, some reluctance in characterizing peer review as merely a convergence mechanism. They might also suggest some reluctance in characterizing peer review as purely a mechanism of scientific expertise, because peer deliberations seem to mix science, empirical observations, regulatory craft about enforcement techniques, and even explicitly political issues. And an open question remains whether these transnational communities of technocrats themselves face and are aware of the limits and the crisis of technocratic expertise and authority. And that might be a good point on which to end this talk to the cluster. I look forward to questions and suggestions, and also further correspondence with members of the cluster as we undertake this project. Thank you very much once again.